Prosecutors' offices around the country are beginning to come around to the concept that first-time DUI offenders shouldn't be saddled with DUI convictions for the rest of their lives. That notion, in addition to fiscal reality of bloated police overtime budgets, has spawned DUI diversion programs. They're offered because prosecutors and courts realize that sometimes a DUI is just a mistake. It allows the defendant to rehabilitate himself and demonstrate that he's capable of behaving responsibly. How do these programs work? In a typical diversion program, like the Back on Track program in Miami, Florida, the defendant's required to meet certain specified conditions, such as completing substance abuse classes, community service, payment of fines, and a hefty donation to MAD. Once the conditions are met, the prosecutor's office will either reduce the DUI charge to reckless or dismiss the case altogether. Only first-time DUI offenders are eligible, and even if a prior DUI arrest exists, you'll be ineligible. Some of the other exclusions specific to a case are high breath results over a .20, vehicle crashes, passengers in the car under 18, multiple traffic offenses, and any DUIs in the last 5 years. Many prosecutors' offices require that the defendant plead guilty to the DUI up front, suspending the sentence until the conditions are satisfied. Other states may allow for deferred or withheld adjudication to a lesser charge like reckless driving. Other programs require a plea of guilty to reckless at the outset of the case, making each of the conditions a special condition of probation. The defendant might have to agree to a specified jail term in the event of a willful violation of the program conditions. Another problem arises with the requirement that a defendant must accept responsibility or admit guilt as a prerequisite to acceptance in the program. If a defendant doesn't successfully complete the program, the case returns to court, and the state will attempt to use the admission or confession in court against the defendant. Judges are participating in this charade by securing this statement of responsibility from defendants in open court. It's been known to cause problems with employers whose employee conduct manuals include language about accepting responsibility or guilt to a crime as a cause for termination. Sometimes a lawyer can plead to the state and ask them to waive this requirement by showing the manual section and indicating that the provision would adversely affect the defendant's employment. So you're asking, do I need a lawyer for DUI diversion? Facing DUI charges can be intimidating, and if you need assistance with a DUI charge, you may wish to speak with a DUI lawyer in your area. That lawyer can represent you in court, help determine if you're eligible for a diversion program, and a qualified attorney will be able to assist you during the program to make sure that you complete all the program requirements. I'm attorney Jonathan Blecher.